welcome to the 255th session of Legal Empowerment Through Interaction Lecture Series. Today, we are privileged with the presence of the speaker himself, that is Justice Ramkumar sir, Justice Ramakrishnan sir, Justice Gordon Ram sir, and all of you wonderful participants. And after a hiatus, we have Prem also back on the platform today. Today's topic is exploring the contours of the testimonial compulsion in subjecting an accused to the truth detection tests. As long as there is no truthometer, or there is no, just like the doctor's dilemma, that is, there is no painometer. If the patient says there is a pain, he'll have to assume that there is pain and treat the patient. Just like that, we have certain permutations and combinations which is time tested, by which the adjudicating officer may come to a conclusion that this is more probable than the other, and come to a conclusion that this might be the truth, or this is what is been proved. So today we'll be addressing on this specific and very interesting topic. And without any wastage of time, may I go directly over to Justice Ramkumar.
I have readers for my questions.
Yeah, me and Prem very much available.
Okay. Today we are exploring the feasibility of subjecting an accused person to truth detection test. It's a expression coined by me. Without his truth detection test, without his consent. By the words truth detection test, what I mean is the forcible subjection of an accused person to polygraph test, that is lie detector test, 2, narcoanalysis test, 3, brain electrical activation profile, BEAP, that is brain mapping test, and taking his voice samples for the purpose of identification and comparison of his voice. The obvious purpose of forcing an accused person to undergo the above scientific techniques is for eliciting useful information which is lying hidden inside his mind, which he would not otherwise divulge as a free individual. Before delving deep into this topic, one has to examine the contours of the fundamental right of an accused person against self-incrimination through forced confession, as guaranteed by Article 20, Clause 3 of the Constitution of India. Now, broadly stated, the guarantee in Article 23 of the Constitution is against testimonial compulsion, as observed by a Constitution bench of 8 judges in MP Sharma's case, which we will have occasion to discuss in the course of this webinar. Now, Article 23 of the Constitution reads as follows. No person accused of any offense, shall be compelled to be a witness against himself. 3 important phraseologies are relevant. No person accused of any offense, shall be compelled to be a witness against himself. See, after all, it does not even complete 2 lines, but most of the words are very pregnant with a lot of meaning. We will discuss the contours of this article also. Now, with that, we pass on to questions. In fact, as I usually say, any law is better understood when applied to concrete factual situations. So let us go to the questions.
Sir,
question number
myself,
1.
Prem, and Dilip sir will share the questions. So I thought, like you just mentioned, self-incrimination, and you mentioned about 23 article, wherein nobody shall be deprived of his life or personal liberty, etc.
No, that is 21.
No, 23 is against
no person accused of any offense.
Absolutely, sir. So, what exactly are the protections against testimonial compulsion guaranteed under 23?
Yes.
That is the first question.
It is a protection given to an accused person against compulsion resulting in his giving evidence against himself. It is beautifully explained in MP Sharma versus Satish Chandra, District Magistrate, Delhi, AR 1954, Supreme Court 300. 8 judges, Meherchand Mahajan, Chief Justice, B.K. Mukherjee, S.R. Das, Vivian Bose, Ghulam Hassan, N.H. Bhagwati, and B. Jagannatha Das, and the author of the judgment being Justice B. Jagannatha Das. It was held that it was giving evidence against himself, testimonial compulsion. Now we will go into that the nuances after discussing 2 or 3 questions. Question number 2.
Right.
Question number 2 would be, the protection of Article 20, Clause 3 is available to which all persons?
The protection of Article 20, Clause 3 of the Constitution of India, that is the protection against self-incrimination, that is a compulsion to be a witness against himself, is confined only to a person accused of an offense. There is no constitutional protection to a witness, that is a person other than an accused. However, Sections 132 and 148 of the Indian Evidence Act 1872 confer a sort of limited protection against self-incrimination to witnesses in civil and criminal cases. Raja Narayan Lal Bansilal versus Manik Firoz Mistri, AR 1961, Supreme Court 29. 5 judges, B.P. Sinha, Chief Justice, P.B. Gajendra Gadkar, K.N. Vanchu, K.C. Dasgupta, J.C. Shah. Judgment, author of the judgment being Justice Gajendra Gadkar. Under Section 132 of the Evidence Act, a witness cannot refuse to answer a relevant question on the ground that his answer will incriminate him. He cannot. But the proviso to Section 132 excuses him from answering the question if his answer would subject him to an arrest or prosecution, except one for perjury. Supposing his answer would lead to his arrest or prosecution, that is protected. He cannot be compelled. That is the proviso. For example, we have, in fact, that famous Kumar case in Trivandrum, where a person was subjected to third-degree murder by police officers. There, one of the prosecution witnesses during the course of his examination confessed his complicity in that offense. Thereupon, the trial judge made him an accused. It was impermissible because of the proviso of Section 132. That trial judge is now a judge of the High Court.
No, not that. No. There, I see. Suppose he voluntarily gives a statement.
Not
You cannot compel. Suppose
there is a compulsion. There is a compulsion because the very fact that you are summoned to appear as a witness involves a compulsion. But supposing witness acts, there can be situations where after answering a particular question, witness may volunteer to say. Witness adds. We very often record in the deposition. Witness acts. That may be voluntary answer. Otherwise, there is a compulsion behind every witness testifying on oath, responding to a summons. Then under Section 148 of the Evidence Act, if the question relates to an irrelevant issue, irrelevant matter, then the court will decide whether the witness should be compelled to answer the question, except a question which affects the credit of the witness by injuring his character. These are the 2 provisions in the Evidence Act which gives some sort of limited protection to a witness, but no constitutional protection.
Ramkumar sir, here I
Yes.
may interfere because there is one provision in the evidence. I'm not remembering that, where it says that no action can be taken against a witness which makes some incriminating circumstances against him.
132 proviso. Proviso to Section 132. Yes. Question number 3.
Who and when can a person be said to be a person accused of an offense?
When can you say that any person accused of an offense? No person accused of an offense shall be compelled to be a witness against himself. This is the constitutional provision. Now, who can be said to be a person accused of an offense? To bring the statement of the person concerned within the prohibition of Article 23 of the Constitution of India, such person must have stood in the character of an accused person at the time when he made the statement. At the time when he made the statement, he should have stood in the character of an accused person. How do you decide that? That is, after it is not enough that after making the statement, he subsequently made an accused. After making the statement, the objectionable statement or the impugned statement, if he subsequently made an accused, that is not the protection. Protection is at the time when he makes the statement, he should stand in the position of an accused person. That is the requirement of section Article 20, Clause 3. That at that time he should be an accused. That we will decide how does he become an accused. That we will decide. Paragraph 16, 7. Paragraph 16, 7 of State of Bombay versus Kathikalu Ogad. AR 1961 Supreme Court 1808. 1808. AR 61 Supreme Court 1808. 11 judges. BP Sinha, Chief Justice, Imam, SK Das, Gajendra Gadkar, AK Sarkar, Subbarao, Vanchu, Das Gupta, Dayal, Justice Dayal, Rajagopal Iyengar, and Madolkar, with 3 judges giving concurring judgments. One Chief Justice Imam, then one Das Gupta, and BP Sinha and Das Gupta, 2 judges. Of course, Das Gupta giving a slightly on a different note. Now, a person becomes an accused of an offence within the meaning of Article 23 of the Constitution of India when there is a formal accusation against him, either in the form of an FIR registered against him, in the case of a police investigation, or when there is a complaint filed against him, in the case of a non-police officer. So, if an FIR is registered against him, you can say that here is a person accused of an offence. Or if a complaint is filed, private complaint is filed against such a person, you can say that here is a person accused of offence. If after being accused of an offence, if a statement he is compelled to make a statement, he is protected by Article 20, Clause 3 of the Constitution. Para 11 of MP Sharma, 1954 Supreme Court, page 300. I already said that. Then again, Para 9 of Mohammad Dastagir versus State of Madras, AR 1960 Supreme Court, 756. AR 1960 Supreme Court 756. Again, 5 judges. BP Sinha, Chief Justice, SJ Imam, AK Sarkar, K. Vanchu, and JC Shah. Judgment, author of the judgment is SJ Imam. Again, Kathikalu Ogad, paras 14 and 16 of Kathikalu Ogad, AR 1961 Supreme Court 1808. 11 judges. Then Ramesh Chandra Mehta versus State of West Bengal, AR 1970 Supreme Court 940. 3 judges, Justice Shah, J.C. Shah, Ramaswamy, and Grover, and Justice Shah giving the authoring the judgment. Again, Para 20 of Ramanlal Bogilal Shah versus D.K. Guha, AR 1973 Supreme Court 1196. 5 judges, S.M. Sikri, Chief Justice, is the author of the judgment. A.N. Ray, D.G. Palekar, M.H. Beg, and S.N. Dwivedi, Justice S.N. Dwivedi. Author of the judgment is S.M. Sikri, Chief Justice. All these decisions say that you can call him a person accused of an offence only when an FIR, there is a formal accusation in the form of an FIR being registered against him or a complaint being filed against him. Yes. Question 4.
Sir, after the expression, a person accused of an offence, the next important expression in Article 23 is to be a witness.
Yes.
What exactly is the scope of that expression of words, to be a witness?
He shall not be compelled to be a witness against himself.
Yes.
Now, is there not a contradiction? How can an accused be a witness? A person can be witness not merely by giving oral evidence, but also by producing documents or making intelligent gestures, as in the case of dumb witness under Section 119 of the Evidence Act, etc. It is nothing more than to furnish evidence. To be a witness means he cannot be compelled to furnish evidence. Evidence can be furnished through the lips, speech, or by production of a thing or a document or in other modes, suitably stated by MP Sharma in paragraph 10. When it is said that accused person cannot be compelled to be a witness against himself, it does not mean that accused will be asked to examine himself as a witness. Not like that. Though the article says no person accused of an offence shall be compelled to be a witness against himself, means you are not calling upon the accused to mount the witness box and examine himself. No, that he can do under Section 315, but only on his own consent, that to given in writing. That is not the requirement here. Here you are compelling an accused person to furnish evidence against himself. That is the witness against himself. Question number 5.
So before go to question number 5, sir, So regarding this question number 4, to be a witness in Article 20, Clause 3. Now, Section 91. But our High Court, at least there are 3 judgments. One is Kuriland Private Limited, is a 2008 decision, 2008 4K 8585. Then you have an 86 judgment in Jayadeva Panikar, and of late Justice Thomas P. Joseph. I think it is Rocky. I'm not sure about the particular judgment. But these 3 judgments would say that the direction to an accused person to produce documents that does not amount to testimonial compulsion. Actually, the judgments are wrong, right?
And it offends Shyamlal Mohanlal, 65 Supreme Court. 65 Supreme Court, 5 judges, constitutional bench. Of course, Shyamlal Mohanlal did go a step further than Kathikalu Ogad. Because the Shyamlal Mohanlal 5 judges said that in Kathikalu Ogad, Section 9, the scope of Section 91 CRPC was not considered. And these 5 judges attempted to interpret Section 91 and say that in the case of an accused person, neither the police officer nor the court can invoke Section 91 and call upon an accused person to produce a document. Whatever be the document, cannot be produced, cannot be directed. I have my own reservations about that. Of course, you can't go against the constitutional bench decision.
Not in a case where certain evidence is available with him alone. Documentary evidence, suppose in a case of cheating, documentary evidence or accounts will be only with him. Unless those documents
you cannot compel, but you can conduct a search. You can conduct a search. This is what Shyamlal Mohanlal said. You can conduct a search, but no, you can't direct neither the police or, because the distinction given is very flimsy according to me. The distinction, why the distinction given was both the court as well as the police officer can compel under Section 91 an accused person to produce document in his custody. Now, in the case of a court, court can conduct an inquiry as to his inability. Supposing he says that I cannot produce that document for these reasons, court can conduct an inquiry. But then Shyamlal Mohanlal says, whereas in the case of a police officer has no power of inquiry. Therefore, police officer cannot conduct an inquiry. In view of that, court also should not direct the accused to produce document, whatever be the nature of the document. Because it goes forward, so it has stood the test of time. So,
at the same time,
so far.
So can I ask one thing, sir? Because when I referred to Kuriland was by Justice Giri. So if the court uses its power under 165 of the Evidence Act, if the judge is of the opinion that you have to produce that particular document, because it is necessary to discover the relevant fact to arrive at the real truth, then does a direction by a judge to produce a document, a direction issued under Section 165 of run counter to Article 20, Clause 3?
Court, in fact, court is given higher power. Whatever, even it goes, it overrides even Section 162.
But will it override the constitutional mandates, sir?
It should not. It should not. In fact, of course, the only functionary in the entire gamut of criminal trial who can ask irrelevant question is the presiding judge. Because relevant or irrelevant, that's what the wording of Section 165 says. But whether if the court cannot compel an accused under Section 91 to produce a document, as in the case of a police officer, can that power be overcome by recourse to Section 165 of the Evidence Act? Kerala High Court said so, did not?
Kerala, Justice Giri in this Kuriland.
Yes.
I don't think whether even the court can go against court, because it was interpreting Article 23 that Shyamlal Mohanlal said that even the court cannot compel the accused under Section 91 to produce documents.
But Shyamlal Mohanlal, which is 65 Supreme Court 1251, the Section 91 CRPC, it was construed as excluding only an accused. Because that was what was said in this Kuriland.
Yes.
But to arrive at the real truth, it was only the accused, of course, he is excluded to a certain extent. But if you have to arrive at the real truth, you cannot completely oust him from the purview of Section 91. That was what was held by Justice Giri. Because I think
Because,
Shyamlal Mohan
uh,
was considered. by Justice-
Article 23 does not say either police officer or court or private person. No person accused of an offense shall be compelled to be a witness against himself. That direction is not only to court, not only to police officer, not only to non-police officer, not only to persons in authority falling under section 24. So it is a blanket ban. How can it be violated? I have my own doubts. Anyway,
Absolutely true.
Just see the second proviso to 165.
yes,
Prem,
One-
165 second proviso. 165 second proviso of Evidence Act.
Gives an opportunity to the other side to explain or to.
provided also that
section
this
shall not
section shall
authorize-
not authorize any judge to compel any witness to answer any question or to produce any document which such witness would be entitled to refuse to answer or produce under section 121 to 131, both inclusive.
That is
If the
privilege,
questions-
privilege statements.
privilege. If the questions were asked or the documents were called for by the adverse party, nor shall the judge ask any question which would be improper for any other person to ask under section 148 or 149, nor shall he dispense with the primary evidence of any document except in the cases hereinbefore accepted. But it refers to the other provisions of the Evidence Act only. It does not refer to constitutional provision. Article 23. But Article 23 is a prohibition, is an injunction. Not only, it does not say no police officer shall compel a person.
Well,
It
not
does
that
not
one,
say-
no, 165 also does not say that you can ask the accused. Any witness present or any witness required for that purpose can be summoned, that's all. Not the accused.
Anyway, court can ask any question relevant or irrelevant.
No, that too for to the witnesses. During the course of
During the course of examination.
examination,
of witness.
not against the accused.
Yes.
Now,
And we
question
pass
number
on.
5.
Yes.
Question number
Probably
5.
313 is the only area where court can frame questions and ask the questions. If the court feels that some explanation is required, that too, which the incriminating circumstances brought in the course of examination.
That's a
Not otherwise.
facet of audio alterum partum. The
Not
facet of
otherwise.
audio alterum partum.
Not
And
otherwise.
84 Supreme Court that Sharad Birdich and Sharada said that if any incriminating question is not put to the accused and his explanation elicited, it cannot be used against him for convicting him.
So subsequently,
Absolutely.
I think Justice Thomas has had a different view, saying
No.
that if it is within his knowledge, if it is not said, it can be taken as a missing link to be supplied for the purpose of
That is a
completing the
different
chain.
thing.
Completing the chain.
Giving a false answer, etc. That's a different thing. But if a particular incriminating circumstance is not put to him, his explanation is not elicited, and the court makes use of that circumstance for convicting him, nothing doing, cannot be done. Yes.
Now, the question is that if not the protection under Article 20, Clause 3 of the Constitution of India available to an accused only when the case reaches a stage of trial while examination of the witnesses take place?
No, the protection is available to an accused person the moment he is formally made an accused by registering an FIR or by filing a complaint against him. And the said protection will continue to be available to him till the end of trial. MP Sharma again, same decision, 54 Supreme Court 300. Although decisions go to the same effect, same. Yes. Question number 6.
With regard to the words, person accused of an offense, is there any distinction between Article 20, Clause 3 of the Constitution of India and Section 24 to 27 CRPC?
Yes, in fact, not only Article 23 of the Constitution of India, Section 24 to 27 CRPC also use the same expression, person accused of an offense or an accused person. So, how can they be differently interpreted? Can those words, person accused of an offense, be differently interpreted? Was the question which arose before a constitutional bench of the Supreme Court in State of UP versus Dyoman Upadhyaya, AR 1960 Supreme Court 1125. 5 judges, S.K. Das, J.L. Kapoor, K. Subbarao, Hidayatullah, and Justice J.C. Shah. There, Justice Subbarao made a dissenting view. All others concurred to hold that the 24 to 27, though use the same expression, person accused of an offense, at the time when his statement is recorded, he need not stand in the position, character of an accused person, unlike Article 20, Clause 3 of the Constitution. While Article 23, Clause 3 insists that he should have stood in the position of an accused by the filing of an FIR, by the registration of an FIR or filing of a complaint. In the case of 24 to 27, it is not necessary at the time when he made the statement. It is not necessary that he should be formally accused of an offense, but it is enough that he subsequently becomes an accused. Therefore, the words person accused of an offense in sections 24 to 27 were interpreted to mean that it is only descriptive of his subsequent status. Person accused of an offense in sections 24 to 27 are only descriptive of his subsequent status. Subsequently became a person accused of an offense. That is the meaning to be attributed to these three sections. In fact, in way back in 1929, in Pakkala Narayana Swami versus King Emperor, year 1929, Privy Council 47, Lord Atkin, speaking for the Privy Council, held that in paragraph 51, that even a statement made by a person occurring in 162 CRPC, there also under section 162 CRPC also, person accused of an offense means that person need not be a person accused of an offense at that time. He need not be formally accused. It is enough that he is only a suspect and eventually he becomes an accused. If he eventually becomes an accused, that will meet the requirements of section 161, 161(2), 162, etc. also. So therefore, this distinction has to be borne in mind. While under Article 23 of the Constitution, 20 Clause 3 of the Constitution, at the time when he makes the statement, he should be a person accused of an offense in the form of a formal FIR being registered against him or a complaint filed against him. But in the case of 24 to 27, it is enough that he is only a suspect and he becomes an accused only subsequently. The expression person accused of an offense is only descriptive of his subsequent status of an accused. Then question number
7.
Accused a right to silence or right of silence.
Yes, accused has got a right of silence. There's a beautiful article by Mr. Prem Raj Menon. You can give the citation. In fact, in Selvi versus State of Karnataka, AR 2010 Supreme Court 1974, 3 judges, Justice K.G. Balakrishnan, Chief Justice, R. Ravindran, and J.M. Panchal. The judgment, author of the judgment being Chief Justice K.G. Balakrishnan. The interplay of Articles 20, Clause 3 and 21 of the Constitution of India and Sections 313, Clause 3, Proviso B to Section 315, Clause 1 and Section 161(2) of CRPC have been discussed in detail in paragraphs 84 and 192 of Selvi, year 2010 Supreme Court 1974. So he has got a right of silence. That has
And
been
this was the
in fact, Nandini Satpathy, all those, this is Justice Krishna Iyer.
case. 78 Supreme Court 1025. That is the first case.
Yes, all these considered in Selvi. Selvi has considered all these things. Some of us initially used to, without reading Selvi, used to feel that that's a judgment in the interest of the, they rendered in the interest of the one of the judges. But after reading Selvi, it's a beautiful judgment.
Selvi actually, Dushyant Dave was the amicus curiae in Selvi. Were giants like Harish Salve was the Gulam Vahanvadi also was there. There's a beautiful judgment also. Now
Yes.
moving to question number 8.
8.
Is not the protection of Article 20, Clause 3 available to a suspect if forced confession is taken even before formal accusation?
We already answered that in the case of a suspect, that the protection is not available. Therefore, at a time when a person is only a suspect, he can be compelled to be a witness against himself. Article 23 is not violated. The para 40 of Nandini Satpathy versus P.L. Dani. Para 40 of Nandini Satpathy versus P.L. Dani. AR 1978, Supreme Court, 1025. 3 judges. Judgment by Justice E.R. Krishnaiyer. Then again, Bhagavan Das Goenka versus, in fact, Bhagavan Das Goenka versus Union of India, AR 1961 Madras, 47 has been relied on by Justice Krishnaiyer in that decision. But then, where forced or voluntary, whether it is forced or voluntary, if a confession is made to a police officer either before the commencement of investigation or during investigation or otherwise and in the course of investigation, it will be hit by section 25 of the Evidence Act. And if it is made during the course of investigation, it will be hit by section 161, 162, CRPC also, unless it distinctly relates to the discovery of a fact within the meaning of section 27 of the Evidence Act. Otherwise, 25, 162 also will apply. Article 23 also. Article 23, section 25 and section 162. 3 statutes, 1 constitution, then section 25 of the Evidence Act, and 162 CRPs. All will apply. If it is a confession made during the course of investigation to a police officer. Unless it results in a recovery, falling under section 27 of the Evidence Act.
Now, so again, when we are in this Nandini Satpathy's case, because for this particular, the answer was Nandini Satpathy. Now, kindly see, sir, section 161 of the CRPC. Of course, it heads to examination of witness by the police, but in the body,
it includes accused person also. Person accused of an offence also.
161 clause 2. 161 clause 2, that was considered in Nandini Satpathy. And there's a beautiful line in Nandini Satpathy, considering this 161 clause 2 with article 23. Now, Justice Krishnaiyer goes on to say, he really expresses a view that the terminological expression apart, section 162 CRPC is just a parliamentary clause on the constitutional clause of article 20 clause 3, which is absolutely correct. Because
the body of the section does not use the expression witness. Only the title. Body of the section only says any person supposed to be acquainted with the facts and circumstances of the case. That can certainly include the accused. He is the best person who is acquainted with the facts and circumstances of the case.
And clause 2 has to answer.
Yes.
Is there not question number 9? Is there not a compulsion because statement of the accused is recorded while in police custody?
Because if a person is in police custody, that will it not by itself amount to compulsion? Will it not amount to a person being compelled to make a statement? Because he is in police custody. There the Constitutional Bench answered that question. No, an accused person cannot be said to have been compelled to be a witness against himself simply because he made a statement while in police custody, without anything more. In other words, the mere fact of being in police custody at the time when the statement was made would not by itself, as a proposition of law, lead to the inference that the accused was compelled to make a statement, though that fact in conjunction with some other extraneous circumstances, may taint the statement. That's all. That is what paragraph 16(1) of Kathikalu Ogad, 61 Supreme Court, beautifully observed that. Just because he is in police custody, you can't infer that his statement has been obtained forced confession. His statement is a forced confession. You cannot infer. But he may have to say that no, I was forced. In fact, that is the next question. Next question is relating to that.
Question number 10 is that when can it be said that an accused person is compelled?
This question is a sequel to the earlier question. In para 15 of Kathikalu Ogad, the Constitutional Bench added, of course, it is open to an accused person to show that while he was in police custody at the relevant time, he was subjected to treatment which in the circumstance of the case would lend itself to the inference that compulsion was in fact exercised. In other words, it will be a question of fact in each case to be determined by the court on weighing the facts and circumstances disclosed in the evidence before it. Therefore, it will be for the accused to bring in evidence to show that it was not a mere statement made in custody. In fact, I was compelled to make that statement. There was a physical, or in fact that has been beautifully stated by Krishna in Justice in Nandini Satpathi's case. Justice Krishna, compelled testimony is evidence procured not merely by physical threat, violence, psychic torture, atmospheric pressure. I didn't understand that expression. Atmospheric pressure, environmental coercion, tiring interrogative prolixity. Very often this Directorate of Enforcement, they resort to this only: tiring interrogative prolixity, overbearing and intimidatory methods, and the like. Beautifully stated by Justice Krishna in paragraph 53 of Nandini Satpathy, year 1978, Supreme Court 1025, 3 judges. Yes, question number 11.
No, the technique which the police adopt is, they will keep one witness, they will beat up another fellow in front of them.
Yes.
By seeing that other fellow being beaten up, these people get scared.
Yes.
They don't have these will.
All come within the overbearing, intimidatory methods mentioned by Justice Krishna or interrogative prolixity.
Emotional compulsion also will be there. Emotional pressure.
All those things.
Pressure.
Atmospheric pressure.
That I couldn't understand. The expansion
No, because
of that.
the atmosphere would be surged with some sort of tension.
Fully
the
charged
witness-
atmosphere.
No, suppose you have been say that if you didn't say so, I will torture your family members also. They also
That
will be made
is
an
not
accused.
that. The surcharged atmosphere being created.
Yes.
Maybe, I don't know. Question 11.
When does an accused person become a witness against himself under Article 23?
That to be a witness means imparting knowledge in respect of relevant facts by means of oral or written statement. Though he is an accused, though he is not entering the witness box to depose before court, he becomes a witness against himself by imparting knowledge or in respect of relevant facts by means of oral or written statement. Or rather, he is being compelled to reveal his personal knowledge regarding the facts in issue, or regarding the facts, the facts in issue which is exclusively known to him only, which is lying deep in his mind. He is compelled to reveal those facts either in the form of an oral statement or written statement. That is how he becomes a witness against himself.
For example,
Yeah.
that private defense, he will have to say, he will have to admit his presence and on one circumstance he had
No,
exercised
that is
that
not
right.
that. That is not that. Here, you are compelling him to make a statement as to, for example, he is asked, how are you not the accused in this case? He is asked to confess before a police officer, hit by section 25. And if he is asked to reveal his personal knowledge regarding the occurrence, regarding the offense, he is compelled to be a witness against himself. Or what is the mode by which you committed this murder? These are all testimonial compulsion. He is compelled to make a statement against himself. The paragraph 16, clause 5, paragraph 16.5 in Kathikalu Agad has been beautifully stated by the Supreme Court. Self-incrimination. What amount to self-incrimination? Question number 12.
Imparting knowledge.
What are the permissible acts?
His personal knowledge regarding the facts constituting the offense. Regarding the facts constituting the offense, he alone has got his personal knowledge. He is called upon to divulge his personal knowledge about the facts constituting the offense. That amounts to testimonial compulsion.
Question number 12. What are the permissible acts which do not infringe Article 20, Clause 3 of the Constitution?
There is a tightrope walking done by courts. In a narrow or strict sense, the word to be a witness.
Ramkumar sir should not reveal such things. There are a lot of police officers who will be waiting for such kind of things.
in a narrow or strict sense of the word, to be a witness in Article 23 of the Constitution of India, the Constitutional Bench held that it may be equivalent to furnishing evidence. He is called upon to furnishing evidence by means of oral or written statement, but not in the larger sense of the said word, which may include giving of thumb impression. Giving of thumb impression, by asking him to give his thumb impression, he is not called upon to convey his personal knowledge regarding the facts constituting the offense. To give his thumb impressions of palm, giving his impressions of foot, asking him to give impressions of fingers, asking him to give specimen handwriting, asking him to give specimen signatures, blood specimens, production of documents for conveying his personal knowledge regarding the occurrence. For example, supposing he has written a letter, or he has kept an office copy of the letter sent by him confessing the guilt to a friend of his. He has kept an office copy, calling upon him to produce. It's not merely a request for a compulsion. That document will convey his personal knowledge regarding the facts constituting the offense. Then giving material objects, exposing parts of the body, pointing out the place where corpus delicti was lying and discovery made within the scope of section 27. These are all outside the pale of Article 20, Clause 3. Then again in State of Bombay versus Kathikalu, that you find this in paragraphs 12, 13 and 16 of Kathikalu. Then again in Selvi, giving of semen, giving a specimen of semen, giving sputum, giving sweat, giving hair samples, giving fingernail clippings. All these things go outside the restriction under Article 23 of the Constitution of India, because they don't have the effect of conveying or imparting his personal knowledge regarding the facts constituting the offense. Of course, when intelligently used, they may
point out the guilt.
Yeah.
Or participation.
Para 140, Para 148 of Selvi, year 2010, Supreme Court 1974, beautifully stated. Then Mohammad Dastagir, year 1960, Supreme Court 7565 judges, all those things. In so even written or oral statement conveying his personal knowledge, which is very much in his mind, if he is compelled to make that statement regarding the facts constituting the offense, you are compelling him to be a witness against himself, not by asking him to give evidence as a witness. No, as an accused, he has got that constitutional protection. Yes, question 13.
Question 13. Which are the scientific techniques coming under the mischief of Article 20, Clause 3 of the Constitution?
Going by Selvi, polygraph test, lie detector test, narcoanalysis test, and brain electrical activation profile, brain mapping tests are the tests which attract the embargo under Article 23 of the Constitution of India. Question 14.
Why is it that subjecting an accused person to the above scientific tests without his consent is said to violate the right against self-incrimination?
Administration of the above scientific techniques without his consent that amounts to forcible or compulsory administration and violates the right against self-incrimination guaranteed by Article 23, since the results obtained from each of the above tests bear a testimonial character. By the para 221 of Selvi, AR 2010, Supreme Court 1974. This is because these tests involve substantial reliance on the personal knowledge of the subject and hence is involuntary administration. Administration without his consent offends the right against self-incrimination, because these are all in his mind. By giving him some drugs, by inducing him under a drug, he is called upon to reveal his knowledge. So, consciously or unconsciously or subconsciously, he is called upon to reveal his personal knowledge regarding the facts constituting the offense by administering a drug and putting him under a trance. Therefore, that also amounts to self-incrimination. MP administration without his consent. There was a hint given in MP Sharma's case, 54th Supreme Court 300. Then Selvi, in fact, MP Sharma said communication by lips, then production of thing, document, pointing out, nodding, he said, all those things are answers conveying his personal knowledge. If the nodding or pointing out amounts to conveying his personal knowledge regarding the facts constituting the offense, it offends Article 23. Then in Selvi, they went one step further to say that subjecting him to such tests amount to cruel, inhuman, and degrading treatment. Cruel, inhuman, and degrading treatment within the meaning of evolving international human rights norms. You may refer to paragraphs 194 to 222 of Selvi. The body of principles for protection of all persons under any form of detention or imprisonment 1988 were re-emphasized in Selvi. In the case of narcoanalysis technique, the subject speaks in a drug-induced state and is clearly not aware of his or her responses at that time. Therefore, it amounts, the three-judge bench, speaking through Justice K.G. Balakrishnan, held that it amounts to imparting his personal knowledge regarding the facts constituting the offense, knowingly or unknowingly or subconsciously or consciously. Yes. 15.
Please, sir.
Whether the impugned techniques can be read into the explanation A to section 53 or into section 53A or section 54 of the RPC.
One important aspect considered by Selvi was whether the explanation, newly introduced explanation with effect from 31/12/2009 explanation and section 54 which was substituted with effect from 31/12/2009 and the newly introduced explanation with effect brought inserted with effect from 23/6/2006 to sections 53 and 53A, which refers to modern scientific techniques including DNA profiling. Then the court was concerned whether the narcoanalysis, brain mapping test, polygraph, etc. could be read as adjustum generis to DNA profiling. Supreme Court said no, it cannot be read as adjustum generis because in DNA profiling, you are not calling upon the accused to convey his personal knowledge. You are only asking him to supply his DNA samples, like as in the case of blood samples, as in the case of asking him to give signatures, specimen writing, specimen semen, sputum, etc. But here you are putting him under a trance and asking him questions. We do not know what are the questions, the type of questions asked. Even leading questions might be asked. We do not know. And he is asked to convey his personal knowledge regarding the facts constituting the offense. It has nothing to do with the DNA profiling or DNA sample. This is what beautifully stated in paragraphs 149 and 222 of Selvi, year 2010, Supreme Court, 1974. Question 16.
Question 16 is that whether the taking and retention of DNA samples violate the rule against self-incrimination.
No, because as in the case of taking blood samples, taking other samples, etc., Selvi said the taking of DNA sample will not from a cell, blood or any other cell of the person concerned. You are not calling upon him to convey his personal knowledge, etc. Therefore, it does not violate Article 23 of the Constitution of India. But there is a word of caution in para 188. If the DNA profiling technique is further developed and used for testimonial purposes, then such user in future could cause challenges in the judicial domain. It's a word of caution in paragraph 188 of Selvi. Then that's all.
17, sir. Whether the narco analysis test is an intrusion into the right to privacy, including physical and mental privacy of the test subject.
It is. What Selvi said was, it is amount of forcible extraction of testimonial responses in a person. Forcible extraction of testimonial responses in a person and subjecting a person to the impune techniques in an involuntary manner violates the prescribed boundaries of mental privacy also. Forcible interference with a person's mental, in fact, this was prior to Puttaswamy judgment. Still the court was foreseeing the mental privacy, and right against self-incrimination was held to be extraction of bodily substances, use of reasonable force of subjecting. In fact, physical privacy, on the other hand, involves ordinary exercise of police powers, contemplating restraints on physical nature, such as extraction of bodily substances, use of reasonable force for subjecting a person to medical examination, as permitted in Section 53 CRPC, then arrest and detention, search and seizure, etc. But compulsory administration of any of the scientific techniques like narcoanalysis, etc., would therefore be an unjustified intrusion into the mental privacy of the individual. Paragraphs 191 to 193 and 222 of Selvi. So it's a very long judgment. Therefore, it is always better to note the paragraph. 191 to 193 and 222. Selvi. 2010 Supreme Court, 1974. Question 18.
Dilip sir.
Question 18. Are there any guidelines laid down for taking the consent of the accused for the scientific techniques? And if so, what are they?
Now, Selvi was very categorical that you cannot subject a person to this test without taking his consent. The consent of the accused for the above techniques should be obtained in accordance with the guidelines for administration of polygraph test, that is lie detector test, as laid down in the year 2000 by the National Human Rights Commission. You will get these guidelines extracted in paragraph 223 of Selvi. Paragraph 223 of Selvi extracts the guidelines. The guidelines, I will read that page. No lie detector test should be administered except on the basis of consent of the accused. An option should be given to the accused whether he wishes to avail of such test or not. 2. If the accused volunteers for a lie detector test, he should be given access to a lawyer, and the physical, emotional, and legal implications of such a test should be explained to him by the police and by his lawyer. Informed consent, taking informed consent. Then the consent should be recorded before a judicial magistrate, not outside. During the hearing before the magistrate, the person alleged to have agreed should be duly represented by a lawyer. 5th condition. At the hearing, the person in question should also be told in clear terms that the statement that is made shall not be a confessional statement to the magistrate, but will have the status of a statement made to a police. See, it will have the status of a statement made to a police. Then the magistrate shall consider all facts relating to the detention, including the length of detention and the nature of interrogation. The actual 7th this actual recording of the lie detector test shall be done by an independent agency such as a hospital and conducted in the presence of a lawyer. How far these are all observed is I don't know, but a real assailant, real culprit may not agree for this, but a person who is really innocent, he may definitely agree for a lie detector test or for narcoanalysis. So he knows that he is fully innocent. So nothing wrong in his giving consent. A full medical and factual narration of the manner of the information received must be taken on record. These are all the guidelines laid down by the National Human Rights Commission. Then question number 19.
Question number 19. When the test subject undergoes the scientific techniques, what are the disadvantages which would stand in the way of the test results being admitted in evidence?
So even when he is undergoing the test with his consent, what are the disadvantages? Even when the subject has given consent to undergo above techniques, the test results cannot be admitted as evidence because the subject does not exercise conscious control over his responses during the administration of the test. Paragraph 223 of Selvi. Since the subject is not immediately aware of the contents of the drug-induced revelations or substantive inferences, it is also conceivable educators may choose not to communicate them to the subject even after completing the test. He adapts at the time of making the statement. He is not aware, conscious of the statements he is making. In fact, the conductors of the test also may keep him in the dark. In fact, statements may be recorded on or charges framed without the knowledge of the test subject. At the stage of trial, the prosecution is obliged to supply copies of all incriminating material to the defendant, but reliance on the impugned test could curtail the opportunity of presenting a meaningful and wholesome defense. If the contents of the revelations or inferences are communicated much later to the defendant, there may not be sufficient time to prepare an adequate defense. These are all the disadvantages conceived by Selvi. Para 209 of Selvi. Question 20.
You're on mute, Shyam. You're on mute.
Shyam?
Am I
You are-
on? Yeah.
Yes.
So question number 20 is, can vulnerability and questionable reliability be attributed to the test results?
Yes, they are the attributes, they are the expressions used by the Supreme Court in Selvi. The Supreme Court had surveyed some foreign judicial precedents dealing with each of the tests in question. A common concern expressed with regard to each of these techniques was the questionable reliability of the results generated by these tests. In respect of narco-analysis technique, it was observed that there is no guarantee that the drug-induced revelations will be truthful. Even without any drug, there is no guarantee that. Yes. Furthermore, empirical studies have shown that during the hypnotic stage, individuals are prone to suggestibility, and there is a good chance that false results could lead to a finding of guilt or innocence. There can be false results. There's an element of suggestibility, especially when if leading questions are asked, which are not to be asked even in a court of law. We do not know. It involves a question of suggestibility also. Why paragraph 210 of Selvi. Yes, question number 21.
Are there factors contributing to the scope for errors in the test results?
Whether there is any scope for errors?
Yes.
There is. As far as polygraph examination is concerned, though there are some studies showing improvements in the accuracy of results with advancement in technology, there is always scope for error on account of several factors. Objections can be raised about the qualifications of the examiner, the physical conditions under which test was conducted, the manner in which questions were framed, the possible use of countermeasures by the test subject. A significant criticism of polygraphy is that sometimes the physiological responses triggered by feelings such as anxiety and fear could be misread as those triggered by deception. It may not be deception, but there could be such a false impression. Similarly, with P30 wave test, there are inherent limitations such as subject having had prior exposure to the probes, which are used as stimuli. Furthermore, this technique has not been the focus of rigorous independent studies. All these judicially taken note of by the Supreme Court. The questionable scientific reliability of these techniques comes into conflict with the standard of proof beyond reasonable doubt, which is an essential feature of criminal trials. It has been beautifully stated in Selvi, paragraph 210. Question 22.
Is any part of the results of the scientific test admissible in evidence during the trial of the case?
The only bit of evidence which is admissible is recovery evidence. After taking his consent, etc., if his statement during trance amounts to leads to the recovery of a fact within the meaning of section 27, that is the only admissible evidence before a court of law. Otherwise, he is not evidence at all before a court of law. voluntary administered test 27, para 223 of Selby. Question 23.
So we have been referring to Selby's case. What exactly was the conclusion of the Supreme Court in that?
1. Compulsory administration of impugned techniques violates the right against self-incrimination. This is because the underlying rationale of the said right is to ensure the reliability as well as voluntariness of the statements that are admitted in evidence. Number 2, this court, Supreme Court, has recognized that the protective scope of Article 23 extends to the investigative stage in criminal cases, and when read with Section 161(2) CRPC, it protects accused persons, suspects as well as witnesses who are examined during an investigation. While under Article 23, he should be formally accused of an offense, but under Sections 161, 162 CRPC, even suspect is not safe. Then third, the test results cannot be admitted in evidence if they have been obtained through the use of compulsion. 4. Article 23 protects an individual's choice between speaking and remaining silent, irrespective of whether the subsequent testimony proves to be inculpatory or exculpatory, even if it is accusing him or not accusing him. It cannot be choice between speaking and remaining silent. Then Article 23 aims to prevent the forcible conveyance of personal knowledge that is relevant to the facts in issue. If he is called upon to convey his personal knowledge relevant to the facts in issue, Article 23 squarely applies. The results obtained from each of the impugned tests bear a testimonial character and they cannot be categorized as material evidence. We are also of the view that forcing an individual to undergo any of the impugned technique violates the standard of substantive due process, which is required for restraining personal liberty. Such a violation will occur irrespective of whether these techniques are forcibly administered during the course of an investigation or for any other purpose, since the test results could also expose a person to adverse consequences of a non-penal nature. Then impugned techniques cannot be read into the statutory provisions which enable medical examination during investigation in criminal cases. That is explanation to Section 53, 53A, etc. And cannot be looked into. Then we have also elaborated how the compulsory administration of any of these techniques is an unjustified intrusion into the mental privacy of the individual. These are all summing up by the Supreme Court. It would also amount to cruel, inhuman, and degrading treatment with regard to the language of evolving international human rights norms. And furthermore, placing reliance on the results gathered from these techniques comes into conflict with the right to fair trial. It will certainly not give rise to a fair trial. Invocations of a compelling public interest cannot justify the dilution of constitutional rights, such as the right against self-incrimination, etc. Paragraph 221 of Selby. Yes, question number 24.
Question number 24. What was the declaration of law made by the Supreme Court in Selby's case?
Selby declared the law as under. In the light of these conclusions, we hold that no individual should be forcibly subjected to any of the techniques in question, whether in the context of investigation in criminal cases or otherwise. Doing so would amount to an unwarranted intrusion into personal liberty, number one. Second, declaration of law. However, we do not leave room for voluntary administration of the impugned techniques in the context of criminal justice, provided that certain safeguards are in place. Even when the subject has given consent to undergo any of these tests, test results by themselves cannot be admitted in evidence because subject does not exercise conscious control over the responses during the administration of the test. Then thirdly, however, any information or material that is subsequently discovered with the help of voluntarily administered test results can be admitted in accordance with Section 27 if it results in the discovery of a fact falling under Section 27 of the Evidence Act. This is the only iota of only piece of evidence which is admissible. That too, if he undergoes the test with his consent. Question 25. Last question.
Last question. Can a judicial magistrate authorize an investigating agency to record the voice samples of an accused person for the purpose of identification during investigation in the absence of any enabling provision in the newly added section 311A CRPC and the newly added explanation to section 53 and 53A CRPC?
Even though section 311A and the explanation to sections 53 and 53A have been newly added, there is no voice samples taken care of. But then the compulsion of the accused to give his voice sample for identification and comparison, as we have already noted, does not amount to furnishing evidence against himself, because he is not asked to convey his personal knowledge. He is only asked to give his voice samples for the purpose of identification or comparison with already the questioned voice samples. Therefore, there is no question of Article 23 being violated. Testimonial compulsion is not being violated. The recent decision of the Supreme Court in Ritesh Singh versus State of UP, AR 2009, Ritesh Singh, Ritesh, R-I-T-E-S-H. Ritesh.
Sinha. Yeah, Ritesh Sinha.
Sinha, I'm sorry. Yeah, Ritesh Sinha versus State of UP, AR 2019 Supreme Court 3592, 3 judges, judgment by Justice Chief Justice Ranjan Gogoi. The omission to include voice samples in the newly introduced section 311A CRPC and the explanation to section 53 and 53A CRPC may be a void which must be filled on the principle of ejusdem generis and on the principle of imminent necessity. This is what the Supreme Court said. It is, of course, it is a causus omissus or void, but then it can be supplied by the principle of ejusdem generis and imminent necessity. This is what the Supreme Court said in paragraph 21 of Ritesh Singh Sinha. A voice print is a visual recording of a voice. What exactly is a voice print? That they have articulated on. Is a visual recording of a voice. It mainly depends on the position of the formants, which are concentrates of sound energy at a given frequency. Their position in the frequency domain is unique to each speaker. Voice prints resemble fingerprints in that each has a distinctive voice with characteristic features dictated by voice cavities and articulates. Voice print identification, that is spectrography, can be used to identify the voice of the culprit. It becomes desirable to have an accused person speak for the purpose of giving to the police an opportunity to hear the voice of the accused and try to identify as that of the culprit. A comparison may be desired between the voice of an accused person and the recorded voice of a criminal obtained, say, by telephone tapping, etc. But when the police may like the accused to be compelled to speak for conversion of his recorded voice into a voice print, if the accused were to refuse to furnish such voice, then before this Ritesh Sinha, he could not, nothing could be done. Now, after Ritesh Sinha, he can be compelled to give his voice sample because it does not involve the imparting of his personal knowledge regarding the facts constituting the offense within the meaning of Article 20, Clause 3. These are all my conclusions on Article 23. I might have missed several aspects.
Notice, sir, the last 2009, under the principles of interpretation, causus omissus cannot be included by a judicial pronouncement.
It's void. They say it's a void. It's a void left by the legislature, so court can fill up that void.
Not
on the principle of
142.
Even until the lawmaker makes a law, that will be the law, as we saw in Vishaga and all those cases.
No, Vishaga and those cases, then certain procedures are provided when certain acts are done. It is in
here there is no violation. Here there is no violation of
Article 23. It is not a question of violation.
By taking his voice
when the legislature purposefully omits certain thing to be included in a particular thing, and can it be substituted by the court? Because the principle of causus omissus is not a domain of the court to.
That way, has the legislature included taking of samples of blood samples, sputum, semen, all those fingerprints, etc. No, only 300, after the insertion of 311, only 311A, only there's a statutory intervention. Until then, when Katikalu Oghaz was decided in 1961, was fingerprint samples, etc., included in the legislature?
Probably for the purpose of strengthening or otherwise of Katikalu, legislature would have thought of introducing a provision. But when the
But you can't say that it is exhaustive. They might have, in fact, that's what the Supreme Court says.
Probably you can
They
say
might have
that,
overlooked that.
No, probably you can say the applying the principle of juris generis of certain types that has been mentioned, this also can come. Can they say that being a cause of omissions a void that we are substituting?
No,
it?
they don't say causes of omissions, but they say void. It's a void which can be filled in, and by invoking the principle of ejutem generis. It is known by the society it keeps. It is known by the society it keeps.
Sir, in this context, there is a Latin maxim, expressio unius exclusio ulterius. So if some words are specified in a section, it excludes others.
Oh, see, when it comes to deciding a case, you have different, you call into it different interpretations. That is why you almost get a conflicting decision on almost every aspect of criminal law. That's why I have been telling judicial officers, fortunately, it's a blessing in disguise. For a case, if you want to acquit the case, an accused, take use of these decisions. If you want to convict him, please use these decisions. Only thing is you have to be in utmost good faith. You have to do it in utmost good faith. That's all.
Sir, without getting into the debate of judicial activism or legislative inefficiency, we'll go to Kodandaram sir for his comments.
Sir, I have become a rich man as of late. Enriched with the knowledge, because the very beginning I confess that my exposure to criminal law was very, very minimal. So every word, in fact, I am taking notes. I've been writing notes.
Probably for the purpose of using, become a criminal lawyer as a.
So we can expect a miracle in the Supreme Court.
You can't blame me, Ramkrishnan sir. If I'm being a good student and learning at this stage also, you say a very good
mindset.
Yeah.
That makes you always alert and
Yes.
active.
A lot of, in fact, only thing is, as the Ramkrishnan sir said, Ramkumar sir, looks like that there are this MP Sharma's case and
Yes.
then the Selvi's case.
Katikalu.
Selvi's case and that, what is that name?
Katikalu.
Katikalu case. They seems to be playing, throwing a light on many aspects of the Article 23.
Yes.
In the process.
Yes. In fact, that Dioman Upadhyay's case, the question was whether there is a discrimination of Article 27, Section 27 of the Evidence Act, whether it is discriminatory and offending Article 14 of the Constitution of India. One judge at least, Justice no less a person than Justice Subbarao, held that his lordship struck down 27 as violative of Article 14. The majority held otherwise. Because there is a distinction made by in the case of a person in custody, in police custody, and a person not in police custody. According to Justice Subbarao, very beautiful reasoning given. They are saying that you can't, by that very distinction, it brings about a discrimination of Section 27, which cannot stand the test of Article 14. That's what his lordship said.
Thank you, sir. Lot of learning.
Thank you, Kodandaram sir. Ramkrishnan sir, your observation.
It is always a pleasure to hear Ramkumar. That too, when he formulate questions and answers, he goes into all the material aspects and also go into deeper meticulously and then answering the questions. Gives no room for any doubt also for even for a law student who is not having knowledge on that subject, has even not read or not taught the subject. Very a nice presentation, Ramkumar sir.
Thank you, brother.
Sir, Ramkumar sir, I have one, that Little and Company of Chennai, they used to publish 1 rupee books with regard to various aspects in the form of articles. I used to read those things. They're all 1.5 rupee books. With regard
see.
to,
Hey, so cheap,
yeah.
so cheap.
No, it's not the
publication.
question of cheap. In fact, I used to buy in bulk. They wrote in so many topics with respect to those aspects.
Maybe for the law students.
No, not for law students, sir. For general knowledge.
Just like a job wala questions.
With regard to how to save
30
money.
questions. 30
what is the
questions.
need
30
of,
questions.
saving money, and if I have one of those copies, I'll be able to. In fact, I'll request Shyam to ensure publication of each of your talk in that particular form.
It is being considered. It is being
Yes,
considered.
it is being,
all
work
webinars
is
will
on.
be converted into articles also.
Yes.
The work is on, sir.
From my side, any editing job or even proofreading job is required, I'll ready to contribute.
You are already recruited, sir.
No vacancy.
You are already recruited, you are appointed, everything is done.
Thank you.
Instantaneous it is. Dilip, sir.
So quite useful. See, these are the aspects which are required to be taught to the younger generation, would-be lawyers. And the more important thing is they will get interested in the profession.
Not
The-
only,
Seasoned lawyers also for a ready reference, sir. I mean,
not only that, even for judicial officers also it is required for the purpose of understanding the applicability of a particular decision in a particular set of facts. And what are all the things that has been considered, and what is the probative value of that judgment in a particular case? That is also required.
absolutely.
In fact, in Lord Atkin, when he rendered the judgment in Pakkaran Narayana Swami's case, there's a very categoric laying down of the law, saying that Section 25 of the Evidence Act applies in the case of a confession made to a police officer, either before the commencement of investigation or otherwise than in the course of investigation. It was so confusing for me. And what about the confession made during the course of investigation? That is my doubt. Ultimately, would it not be hit by Section 25, a confession made during the course of investigation, if not under 162? Then after that only came subsection 2 to section 162. After Pakala Narayana Swami's case, subsection 2 was inserted, excluding section 32(1) dying declaration and section 27 of the Evidence Act from the purview of the interdict under section 162(1) CRPC.
Even subsequent development Kottaya, that is making 27, what are all the things to be done for the purpose of relying on 27?
What is the fact discovered? Fact discovered is not the weapon discovered. Or they beautifully said weapons were discovered long ago. That's not the fact discovered.
Dilip, sir.
Thank you, sir. Very much. Thank you very much, sir, for this wonderful. Then, my only question is with regard to, suppose if consent is asked for a polygraphic test and he does not give consent, can the court draw an adverse inference against him?
No.
Because I went through a decision.
He has the right to silence.
He has the right to silence, I know. But consent, when given, to be given or not to be given, he says that I am not.
But in the case of TIP, I think if he has refused to undergo TIP, an adverse inference can be.
DNA, etc. There is some observations are somewhere made.
Regarding, and also when he does not offer an explanation for not giving consent, then also.
Because DNA sample and blood sample, etc., the prima facie, there's no violation of Article 23.
Yes.
Whereas narco analysis and lie detector test, prima facie, there is violation. Ultimately, he will be put under a drug-induced state and called upon to impart his personal knowledge regarding the facts constituting the offense.
Yes.
Such a thing does not happen in the case of furnishing, asking him to furnish evidence, furnish signature, furnish blood sample, furnish those things, etc. There lies the difference, probably. I don't know.
No,
in
probably
these also.
Dilip's question, those things were considered in a civil case, it appears, not in a criminal case where adverse inference, question of adverse inference. Because of Article 114. Article 114. Section 114 of the Evidence Act.
Evidence Act
Test
applies to
identification parade, there is a decision. Supposing he refuses to undergo the TI parade, an adverse inference can be drawn. Is that one line of ruling? Is another contrary ruling also. From that alone, adverse inference cannot be.
Recently, I went through a decision where an accused did not offer explanation for his presence in a particular place. Adverse inference was drawn against. And I have forwarded those decisions to you and Prem and Shyam sir also.
Yes.
And I see, only because the accused did not explain as to why he happened to be there at a place.
Not that, Mr. Dilip, there may be distinction because on account of the
You mean the place of occurrence?
Place of occurrence.
Why he happened to be at the place of occurrence?
No, in one part of the building, same building. In another part of the same building.
Not that, in suppose.
Which does not belong to him.
Yes.
Building does not belong to him.
Building belongs to him.
I see. Then he is expected to be there.
He is admitted to be there. See, the court sentenced him, convicted him on the basis of the adverse inference drawn for not explaining as to why he happened to be there at that particular point of time.
If the building belongs to him, he is expected to be there. There is a question of he offering an explanation for being present.
Probably it is a
case of a death of wife death.
Yes.
In the bedroom when he was sitting elsewhere.
We have the other beautiful thing. Last seen together alive. Last seen together alive.
Yes.
Dilip sir, it is just like Abraham Lincoln is said to have, when he was polishing the shoes, some foreign dignitaries said, in our country, we don't polish our shoes. Then he asked them, whose shoes do you polish? Likewise, where else would I be had it not been my house, part of my house? Where else can I?
Yes, sir.
No, if he is not there, then the question will be, where were you at that time?
Yes.
That also will arise.
Correct.
That is a plea of alibi, which he has to prove. Then, of course, maybe it is not his building. Maybe the building does not belong to him.
No, it was,
he was found there.
It was the marital house. Marital house itself.
Oh, then last seen together theory is the best theory.
No, she Celestia committed suicide in the bedroom, closed bedroom. But he was
where he alone was there, is it not? Apart from
his parents were also there in the house.
Oh, but not in the bedroom.
Not
his
in the
bedroom, he was not there.
No.
Okay.
Facts
of the case, maybe.
Yes. Then
Right.
One more question.
Yes.
It's not a question, for a clarification. See, in one question, sir referred to sections 24 to 27. Person accused of any offense.
Descriptive of his subsequent status. Person accused of an offense was not given the same meaning as in Article 20, Clause 3.
But 24 into 27 CRPC.
Yes.
Evidence Act.
But in the question, it was typed as CRPC.
Question
It is Evidence Act.
From that time onwards, I was searching. I couldn't find a single word in that.
I am sorry. It is a mistake. I am sorry. I confess. It's a mistake.
Yeah, that is question number 6 you are referring.
Okay. Oh, Evidence Act. I am sorry. So sorry.
And I was then onwards, I was looking for
the main statute which I always mention every day.
No, this question would have been asked. No, this doubt would have been asked at the time when the question was.
I only asked that question. I also put.
In fact, that question was put by Dilip sir.
Yes.
You read the question.
Yes.
Did not ask.
No. I thought it was my ignorance. Then I was scanning through the.
No, constructive res judicata can be applied.
Sorry, it is evidence. I stand corrected.
Not a stopper, sir.
So, sir, as we come to the end of the 255th session, may I request Prem for the concluding. Over to you, Prem.
Well, that was indeed an erudite exposition of this particular subject by Justice Ramkumar. And I am here after a long spell due to some unavoidable personal inconvenience. And I am now thrilled to meet you all. Now, well, coming to this topic, Article 20, Clause 3, this is principally based on the fundamental facet that no man is obliged to be a witness against himself, almost akin to the Fifth Amendment to the US Constitution. Of course, there is a slight difference you would see between the Fifth Amendment and Article 20, Clause 3. Because the Fifth Amendment reads that no person shall be compelled in any criminal case to be a witness against himself. Whereas 20 Clause 3, as read by Justice Ramkumar, would say, no person accused of an offense shall be compelled to be a witness against himself. And this particular article, it has been a very, very hot topic of our constitutional courts, which by a plethora of precedents have thrown wide the very ambit and scope of the immunity which is granted thereby. Almost like liberally interpreting the word witness, which would appear in that particular article, to include both the oral and the documentary evidence, so that absolutely no person he can be compelled to be a witness to support any prosecution as against him. Now, as Justice Ramkumar put it, one of the first rulings was the 8-judge bench in MP Sharma, 54 Supreme Court 300, which of course stands partly overruled with respect to the privacy facet. And in this judgment, the Supreme Court included within this protection of self-incrimination rule every positive volitional acts which would furnish evidence. And then we have 7 years later, the 11-judge decision in Katikalu Oga, which retains the requirement of this personal volition. And of course, that inter alia, it holds that the self-incrimination must mean like conveying the information which is based upon your personal knowledge, giving information. And finally, regarding the question of narco analysis and brain mapping, etc. Now, the facet of privacy that assumes much significance. Now, here Justice Ramkumar was telling us that this Selvi comes long before Puttaswamy judgment. Now, kindly see, on various kinds of privacy you can have, like you can have the bodily privacy, you can have the spatial privacy, the communicational, the proprietary, you can have the intellectual, the decisional, associational, behavioral, informational, so on. Various types of privacies are there. Now, the 9-judge bench in this Puttaswamy judgment renders a decision. But kindly see the decision. The decision clearly holds that, of course, right to privacy, absolutely, it's an intrinsic element of the right to life and the personal liberty under Article 21, which we see embedded under Part 3 of the Constitution. But unanimously, the judges went on to hold that this particular right of privacy, it is not an absolute right, can be curtailed, because there are certain requirements to fulfill that. It can be curtailed. One is like legality, if you have some statute running counter to that. And the second is the legitimate state interest, or what you call the compelling state interest, which is a very, very, very wide term. Now, it is here where Ritesh Sinha, the last judgment, which Justice Ramkumar told us, 2019-8 SEC page 1, assumes significance. See, this 3-judge bench in Ritesh Sinha, that was indeed a reference which was answered by a 3-judge bench, following a difference of opinion among 2 judges, Justice Ranjana Prakash Desai and Justice Aftab Alam, on 2 vital questions. Now, if you see this 3-judge bench decision, you can see at paragraph number 25 of Ritesh Sinha, it goes on to hold that until provisions are engrafted in the CRPC by the Parliament, the judicial magistrate, he must be conceded the power to order a police, the power to order a person to provide the samples of his voice for the purpose of investigation. Now, such a power has been conferred by a process of judicial interpretation. And kindly says, Supreme Court went on to say that we are doing this under Article 142 of the Constitution of India. Actually, what Justice Ramakrishnan told also assumes much significance. One day, say, causes omissus was attempted. It is like more or less like a judicial legislation. Kindly see, when the Supreme Court makes it clear that we are under 142, there is a decision in Indian Bank's case, 2006 5 SEC 72, which says any direction which is issued by an apex court in the exercise of its power under 142. Of course, it is to do proper justice and the reasons, if any, are given for exercising such power, that cannot be considered as law laid down under Article 141.
That is so. That is so. But then
And
Vishaga,
of course, it's a direction, sir. It's a direction. But here,
and
the Supreme Court-
until a law is enacted, this shall be the law.
Absolutely true, sir. But that is where the other question comes, assumes significance. One is, if it is a causus omissus, because never did the court consider whether that was causus omissus. Because the legislature, of course, you cannot say that the legislature can grasp all the situations. Absolutely true. But the court had to consider whether it was causus omissus. Because if it was causus omissus, the court cannot. Because again, we have a couple of constitutional benches. The last one being Hardeep Singh, 2014, year 2013 Supreme Court 1400. Hardeep Singh. Now, and the court legislate, it's a separate thing. Because if that follows, if the court follows that exercise, then such a power is surely going to lead to incongruous and disastrous results. Disastrous results. Because Ritesh Sinha, of course, to a certain extent, I would say, of course. But kindly see, sir, when the court says it is under 142, we are doing. Because 142 itself has been a very, very hotbed of what I can call is because total confusion. Because 142 of the Constitution, if you see 142 receives its first interpretation in a constitutional bench in Premchand Garg, which is a 63 judgment. Now, Premchand Garg adds a rider to the exercise of that extraordinary powers by laying down that though the powers are too wide, the same is an ancillary power and can be used when not expressly in conflict with the provisions of law. In conflict. So that means either express or implied. Now, this view, 5-judge bench view, that again was accepted by the Supreme Court 4 years later in the 9-judge bench in Naresh Sridhar Mirajkar, 67 Supreme Court, page 1, which again takes in A.R. Antule versus R.S. Naik by a 7-judge bench. And finally, of course, the Supreme Court Bar Association case, 1998 4CC 409. Then 142, because the jurisdiction under 142, if the Supreme Court exercises, that cannot be a binding precedent as under 141. As under 141. Because why I'm saying is, if you take a 54 Supreme Court 300, if you take Karthik Luoga, come back to Ritesh Sinha, if you read Selvi, all these judgments, if you read, you can see, and especially considering Justice Krishna Iyer's view in Nantini Satpathy, 78 judgment, you can see, and 161 clause 2 of the CRPC, you can see this particular, what I would call the woof of the constitutional protection, that has been woven across an extremely entangled wall, because conflicting judgments creating utter confusion. And this has to be disentangled. This topic, I think, needs a further deliberation, because either the Supreme Court has to reconsider this thing. Because
in fact, Article 142 does not say it for laying down the law, for doing complete justice between the parties.
Complete justice between the parties to that list. Of course, that was again and again interpreted that we can, of course, issue directions by the same Supreme Court. And when the Supreme Court says something, we have to accept. But at the same time, sir, when 161 clause 2 of the CRPC, when those words, won't those words run counter to Article 20 clause 3? Because 161 comes during 1974.
Yes.
And we have the Constitution right from 1950. Article 20 clause 3, and kindly see the words in 161 clause 2. Because a careful reading would suggest that, of course, Justice Krishna was correct. It's merely a parliamentary gloss on the entire constitutional clause.
No, even prior to the 1973 code, there was an earlier code which also deals with the recording statement, etc., and its applicability.
But this 161 clause 2, that stands against the Constitution. The other CRPC, that was long before the Constitution.
In fact, in spite of the interpretation in Nandini Sarpathi's case on 161 clause 2, there is a subsequent NMT case from Madras.
Joy Immaculate.
where the
Joint-
three-judge bench held that 160 also uses the word
Suspected
person,
person.
as a
Suspected.
person who is supposed to acquainted with the facts and circumstances. There they said that it applies, it does not apply to women accused.
Ade.
Madras High Court was criticized by the Supreme Court by no less a person than by Justice A.R. Lakshmanan himself.
Anyway, so that is a fantastic class. As Justice Kodandaraman said, we got a lot of learning, and we are all still students.
See, not
I am
only
also.
no, the question is not that. See, when the law is evolving for the purpose of improving the quality of investigation using scientific methods and hindering use of such scientific, because now even the offenses are being done using the technology. When such
Correct.
things are being done, is it not necessary that Article 23 itself has to be revisited for the purpose of providing some protection for the purpose of investigation and getting the probably this, because the Justice Malimat wanted to introduce a civil justice system in the criminal justice also by providing written statement, explaining the defense, etc. But that
Do
was
away
not
with the
accepted.
right to silence.
Yes.
That was not accepted by the parliament. That is a different thing.
Yes.
Because of the constitutional mandate under Article 23 and other thing. Now, there must be some because over the police is also, and we are blaming the police for not getting the accused. How will they collect the evidence? And
Correct, because-
especially in a case where there is no ocular witness, only circumstantial evidence you will have to rely on. There must be some method by which, or some acceptable method. I don't say the third right method. That in one of the decisions, even Justice Thomas has went on to say, merely because some force is the exercise for the purpose of extracting the material required for the purpose of conducting investigation, that will not amount to testimonial compulsion or like that. That cannot be said to be the evidence collected under compulsion. So I feel that blaming the police, blaming this thing, and ultimately when we find that when the investigation is not completed at a particular time, the possibility of the losing of evidence or collection of material evidence also is being lost. How to reconcile?
How many cases High Court, Constitutional Court staying the investigation? How many
Correct.
cases staying the investigation? How can it be done? How can the investigation be stayed? And not to arrest order being passed by the Supreme Court, even after laying down the law for the rest of the
Correct.
country, and don't pass such orders. There is a
Now the
court
Supreme-
violating.
Those are now what the Supreme Court says is not to arrest orders that should mention the reason. That has
Not by a bail itself.
Is it difficult for any judge to give reason? Is it difficult for any judge to give giving reason?
No, even
Umpteen number of reasons can be
he
given.
will acquit the accused even at the time of investigation itself. If the reasons are being given.
So tomorrow in the 256th session, we'll have our friend Sri Anil Malhotra, advocate of Punjab and Haryana High Court.
Sridhar is not coming to complete the
No,
other.
he's not keeping well. That's why last minute. In fact, Sridhar sir was to address us today, and he's not keeping well. So
What time, Shyam?
10:30 sir, in the morning. Habeas corpus for child custody. A means to an end would be the topic tomorrow, and we'll have Anil Malhotra sir exploring the use and misuse of this jurisdiction by different stakeholders
And children also.
very, very vulnerable group. So, sir,
Yes.
thank you very much, Ramkumar sir, for that wonderful session, and thank you, Justice Ramakrishnan sir, Justice Kodandaraman sir.
One more thing. Why don't we invite Justice Kodandaraman to deliver a lecture next Saturday or Sunday?
An electrifying lecture. He gave us once an electrifying lecture
Yes.
on electricity loss.
The invitation has been extended. I think it has been accepted also.
Kodandaraman sir,
Sir,
next week it
We
is
want
your
your
turn.
presence for some subject. Of
You have to teach us
your choice.
topic of your choice. This is how we trap.
It's not a question of, see, the problem is, once we hear Ramkumar sir, we all pale into insignificance.
Why? I have committed so many mistakes even today.
Very good, very good. Anyway, I'll be behind you, sir.
Instead of mentioning Evidence Act, I have mentioned CRP.
And if I may point out, sir, with the greatest respect, you said Chief Justice Imam. Imam was never the Chief Justice.
I mentioned Chief Justice. Yes, yes.
Imam did not become the Chief Justice.
Correct.
Sinha became. After Sinha, Gajendra did.
You are right. You are right. BP Sinha. He was the Chief Justice.
Correct.
So, sir, we'll be behind Kondaram, sir, and I'm sure that he'll pick my phone also. I mean, when I call him today. So, till we meet again tomorrow morning at 10:30 for the session on the use and misuse of the writ of habeas corpus in child custody matters or child issues. Please do take care and stay safe.